can't. So this is the first session of 6 aimed at just bringing up a level of knowledge for quantity surveyors, project managers, employers agents.
Oh, you can hear us. That's great. Thank you.
Anyone involved in working with construction contracts and managing construction contracts. Now, what we find is that there's a sort of slight lack of knowledge in certain areas. Now, hopefully these set of 6 talks will give those of you who are new to it a base grounding in it, and for those of you who are old, wizened, and experienced in this sort of stuff, maybe there'll be a few things that you pick up that you're not aware of. This session, this first one, is aimed at procurement types, contractual relationships, and the issue that we all love, design. I should say this is being recorded as well, should you be mad enough to want to watch it again, or perhaps more likely tell one of your colleagues if they weren't able to make it. So who am I? Well, I'm Andrew Rush, that's me on there. I used to be an engineer. It normally takes me about 30 seconds to say that, so I have again. I'm sort of bizarrely proud of that. I'm the senior partner of the firm, and I've been doing this for a very long time. I'm giving this presentation with I was practicing this last night and I said partner, that didn't feel quite right, but my fellow partner, Hannah, who's going to then take up now.
Good morning, everybody. Thank you for joining us today. My name's Hannah McNabb. As Andrew said, I'm a partner here at Archer. My focus tends to be on the contentious side of the business, and I do a lot of adjudications. But it's not just us 2 that are in the partnership. We've got 6 of us. We're a specialist niche practice. We just do construction law. We've been going for about 4 years now. If you haven't worked it out, Archer is the first initial of our first names. And I can't tell you how long it took us to come up with that. It would have been a lot easier if Ollie was called Edward, but we are where we are. Not just us 6, we've got a range of legal directors, consultants, associates, senior associates, trainees and paralegals, all part of the wider firm. And in total, there's 26 of us. So that's us, and moving on to this session. So session 1, as Andrew said, is about procurement, the interrelationship of various documents, and everyone's favourite topic, design. So starting off with procurement. So what we mean here is not EU or the procedural type of procurement, although obviously that's relevant in certain circumstances. What we mean in this session is the basis of the contractual relationships between the parties.
Oh yeah, we've got a seamless transition between the 2 of us, so you'll realise how seamless it is, because this is my slide. So we're going to talk about, the first section is just talk about the types of procurement. Now there are 8 listed on this slide. We're really going to talk about the top 5. That was quick. The PFI, I'm just going to go PFI, PPP, partnering and frameworks. Less so the PFI one, but the partnering and frameworks, they tend to be an overarching framework agreement, but underneath that, each task order, each works contract does tend to then fall back to one of either the traditional design and build, contracts design portion thing. So the 5 we're going to talk about in practice are the vast bulk of the procurement routes that are used for any contract. So the type of procurement isn't strictly dictated by the form of contract used and vice versa, but as I'll explain in a minute, the JCT side of it probably is, the NEC side of it probably isn't. So if you are JCT, for example, the choice of contract is dictated by whether the contractor is carrying out the design or not. Therefore, if you have a type of procurement that is a design and build type procurement, that will be inextricably linked where JCT is concerned to the form of contract. On the NEC, on the other hand, and for you not that experienced with NEC has various options, but the choice of option is based on the way you pay the contractor, whether it's a fixed price, target price. It's not based on whether there's any design or not. So the procurement route for NEC can still be design and build, whether it be option A, B, C, or D. Whereas JCT, if you're going to have a design and build contract, which I'll come on to in a moment, there will be a design and build procurement route. So there is a slight sort of, it's not always the case that the contract dictates the procurement route. There are some other forms that we will see less commonly. So PPC 2000, which is a form of contract specifically designed to be more partnering. It's typically used by housing associations, not least because the law firm that wrote it, Trowers and Hamlins, works for lots of housing associations. You also get bespoke forms. So for the very large contracts, you'll get bespoke forms. And on top of that, you'll also get amendments to each of these contracts. So what I think the message today you have to get across is contracts get amended. JCT and NEC come up with their contract, which is a sort of, they consider the risk profile that they consider fair. Now, whether we agree with that risk profile or not, that is what the standard form contract says. A funder, a purchaser, a tenant is not necessarily going to be satisfied with that risk apportionment in the standard form. And whether we like it or not, the amendments that get made to these contracts are because those parties say we don't want the risk that those standard forms give us, therefore we want to change it. And there are lots of people who sensibly say, what's wrong with the standard form? Well, the answer is the funder won't give you the money unless you change it. And we have to be sort of realistic about this. It's not all the lawyer's fault. And so for those of you involved in negotiating these, and the same applies to professional appointments, there will be situations where there will be amendments, and they are there because the people giving the money insist upon them. And that theme will come out a few times today, and it's just being aware of that and recognizing that that is an issue.
So what do we mean by traditional procurement? Well, we mean this, which is on the slide. The employer employs a set of design professionals, typically an architect, engineer, and a set of non-design professionals. The design professionals carry out the design of the scheme, and that being the whole scheme. The employer will also appoint contract administrators separately, which could be the architect, could be a QSPM practice. They'd also appoint the principal designer under CDM regs and building regs principal designer now as well. So the employer employs the building contractor to carry out the works only under the building contract. He'll have no design responsibility. The building contractor employs subcontractors to carry out the work. Again, there's no design flowing through. So that's your traditional procurement route, all design kept on the client side. And apparently it was much more common in the 80s and 90s than it is now, although that was way before my time.
So if you're going to use a traditional form of procurement, then for JCT, you're going to need the JCT standard form of contract. Now, you'll be pleased to know if you go onto the JCT website that you can get up to 1% off, which seems a rather bizarre offer. And if you actually read it, the JCT standard building contract without quantities, the most common one, was £114 and is now £113.94p. For those of you who are good at maths, that is not 1% anyway. But just it's made me laugh when I looked for the contracts that you can get up to 1% off for some kind of bargain.
So the second option, and this is the most common option that we see, is pure design and build. So the client, at least theoretically, passes all design responsibility onto the contractor. The contractor will take on full design responsibility, and typically it will have a novation of the consultant team. So the client initially appoints the design professionals who are then novated to the contractor. Now I'll come on to novation in a little while. And also there will need to be a collateral warranty to give back to the employer. So the final position is that the design professionals are employed by the contractor.
Now you'll be pleased to know you can get up to 14% off on the design and build versions, albeit if you look at the standard form, they give you 1 pence off. Which again does seem a sort of slightly unimpressive offer. Moving on to some of the issues that come with design and build, and sort of recognize this is one. So the employer is saying to the contractor, I want you to take the risk of all the design, including pre-contract and post-contract. Now the contractor has to accept this, but his position is, well, I will only accept this if the people who carried out the initial design, I can have a route of recourse against. And so the way they do that is you have a novation, which we'll come on to in a bit. And that effectively means the contract moves from employer to professional to contractor professional. However, the problem with a pure novation is who is left on the client team. You've novated all the consultants, the design consultants, to the contractor. And then any design issues that come up, there's no one left on the design team. So that's one of the issues that comes with pure design and build. The second one is that the type of architect, particularly architects, the type of architect who is employed by an employer can often be a conceptual architect. Often some of the really big practices are employed to get planning and they're not used for the subsequent sort of detailed design. So the party who is novated to the contractor isn't necessarily the sort of company that contractor likes to work with. So you have this situation where the contractor is given parties they aren't necessarily wanting to work with, and the employer has no one on their side. So pure design and build isn't necessarily the correct choice. We get two, hopefully, yep, you get two sort of hybrids, if you want. The first hybrid is where there's still a full design shift to the contractor, but the professionals who've carried out the pre-contract design stay on the employer side, and the contractor employs his own professionals to complete the design. The sort of primary problem with this is you're basically getting two sets of professionals to do the same design, because the first one has done the design and the contractor will only take on the risk if his own professionals have checked the design. So this is a hybrid solution. It often works better because the people who are advising the contractor are more used to working with the contractor, and the client side professionals are still there. So this is one form of hybrid that we see relatively commonly. The other one is a contractor's design portion hybrid. And this is where certain elements are retained by the client, and they tend to be the pretty bits, and the dirty bits are designed by the contractor. Now, what I mean by that really is that the client isn't particularly bothered, the inner workings of the mechanical and electrical services, provided they work. But the client is often very bothered about what the outside looks like, the aesthetics, the cladding. So you end up with a sort of hybrid position where the employer retains some of the design and the contractor designs some of the other portions. Now, if you're using a contractor's design portion contract, you actually use the JCT standard. The standard has sections that are filled in where you fill in whether there are any designed portions or not. So if there's no design, you just put not applicable. If there's certain areas, and the design tends to be piling, precast elements, M&E, roof trusses, the stuff that is not obviously visible tends to be designed by the contractor. There's also another reason it's designed by the contractor. And I go back to the 80s and 90s where I think Hannah might have been born. But in the 80s and 90s, the people who did all the design were the professional team. That shifted over time. So the people who are best placed to do most of the design, if we're being brutally honest, is the supply chain. Things have got more complicated. The supply chain have that technical detail. So I'm a bit of an advocate for not going directly to pure design and build, but using a contractor's design portion. So they're the hybrid versions of traditional design and build, non-novation, and contractor design portion.
So I'm just going to talk about some of the more obscure forms of procurement, and this one's construction management. So under this form, the employer enters directly into trade contracts with each trade contractor, who are basically subcontractors. Now, what it does need is a knowledgeable client that understands it is entering into a series of direct contracts. So the client will still employ their design team, and the issue of who is designing what will still need to be dealt with within the contracts. But the difference here is that we have a construction manager who's typically a contractor, but not always, whose job it is to manage the construction phase and manage the trade contractors. Now, everyone will have heard of Mace. Mace do act as a main contractor, but they made their name as a construction manager. So Mace is the sort of party that would do this job to manage the trades on behalf of the employer. The main reason for this type of method is speed. If a job is time critical, construction management enables an employer to employ trade contractors before the whole of the works are designed. So a good example of this where procurement is used is construction management, is shopping centres or a supermarket where every day of not being open is far more of an issue because of the cost per day. So they're typically used for large projects. The other time this is used is to finish off a job, perhaps where a contractor's gone bust, not an uncommon situation recently.
Management contracting is the fifth one and the least common of the five, and it's not, if you look at the boxes on the screen, it looks pretty similar to a traditional form of procurement. The difference here is that the management contractor is not taking responsibility for the design. So the employer is still employing the design professionals. The management contractor is still employing essentially subcontractors, albeit they're called works contractors. But the management contractor's role is to manage the job, manage the quality, manage the time, but is typically not responsible for the design. Now, you may sort of raise your eyebrows and say, well, quite what's the point? Well, a good example is where a management contractor does not want to take the design. And at the moment, the classic example is recladding. So you've got a contractor who manages the supply chain, but does not want to take responsibility for the design of the new cladding for fairly obvious reasons. The works contractors, who are specialists in that, will adopt that design, and they will enter into direct agreements with the employer. They're essentially collateral warranties, which we'll come on to, but they will enter into direct agreements with the employer. So the employer has a right of recourse for design, with the management contractor is not responsible for the design itself.
So you've decided your procurement route that you're going to take, but how do all the various documents sit together? So this awful looking diagram has been doing the rounds since I was a trainee. You would have thought we'd have updated it by now, but we haven't. But it does show the usual setup of a construction project. So the employer will initially appoint professional consultants, both for the design elements and the non-design elements of the project. There may also be a funding agreement in place with a party providing finance for the project. If there's a forward purchaser, there could be a sale agreement in place. And if there's a tenant lined up, there'll also be an agreement for lease in place. Now, each of these agreements will include obligations that will need to be fed into the building contract. So the contractor will then be appointed and will in turn appoint his subcontractors and possibly subconsultants. There may also be novated consultants. Now, not all of these parties will be linked contractually, and I'm going to come on to why this is important in relation to collateral warranties. Now, whilst every job is different, in truth, almost all schemes boil back to something similar to this setup that we've got on the screen. So, for example, for a social housing scheme, there will be agreements with funders. This may be more central government than commercial funders, but there may be a purchaser for some of the units, often another housing association. If you're building a commercial building with, say, 5 separate units, there's likely to be a funder, 5 tenants or purchasers. If you're building a care home, there's likely to be a funder, maybe a forward funding purchaser, an operating company. Now, all of these parties will have signed documents that need to be fed into the building contract. And that's got to be remembered when you're negotiating building contracts. It's not just the case that the employer's lawyers are being an arse, although this is sometimes the case, but never when we're acting for the employer, of course. Now, it's important to recognise the wider contractual structure and not just the construction documents. Now, this is key because, put bluntly, if the funder's not going to release the money, the project's not going to get built. So we have to recognise that what the funder wants or what the purchaser wants or the tenant wants has to be accommodated.
Moving on to professional appointments, I'm not going to go into too much detail. It's just going back to what Hannah said. I keep coming back to the point, you've got to recognise that there are third parties involved with this. And so the forms of contract, forms of appointment will need to be acceptable to those third parties. So where professional appointments are concerned, the typical situation is the employer will appoint non-design professionals and design professionals. Now, the ones in yellow boxes are the ones who are typically novated. The most typical consultants who are novated are the architect and structural engineer. Sometimes the mechanical, electrical and power engineer will be novated, but not typically nowadays. It comes back to the point I made earlier. The MEP designer now often produces a performance specification rather than does the detailed design, and the detailed design is left with the M&E subcontractor. So this is the sort of normal, going back to the normal setup slide, the employers employing these consultants. Now on some schemes, you can have anything up to 10, 15 different consultants. The question is, what form of contract would you be signing up to with these parties? So if you have a novation, you move to the next one. And that's very simply that those parties get novated to the employer. So they get it from the employer to the building contractor. Some design professionals are left on the employer side, and the non-design professionals are left on the employer side. So what forms of appointment are we seeing that people enter into with professionals? Now, there are standard form appointments that exist for professionals. Now, JCT do produce one. My experience is very, very few people use it. NEC produces one, which is more common if you have an NEC suite of contracts. And you've got ACE that produce it for civil engineers. You've got the RIBA who produce it for the Royal Institute of British Architects. Now, these contracts, they're fine, particularly if you're one of those parties. But the problem is, particularly with the RIBA one and the ACE one, is they're written by a body whose job it is to protect consulting engineers or architects. And based on what I've said so far, it won't come as any surprise to you that the funders and the purchasers and the tenants are not particularly comfortable with contracts that are too pro-consultant. And the best example is some of these contracts contain limits on liability of 10 times the fee or cap of $500,000, let's say. That's not going to buy it on a £10 million job. The funder is not going to accept that. So we need to recognize again, if you're a professional, there will be an element of negotiation of your appointment, but if you expect to be able to sign a standard form, it's just not going to happen. What does happen is the bespoke forms, and they are very typical for any large project. They all law firms and non-law firms have forms of appointment. They are much more pro-client friendly. They don't have limitations of liability. If they do have caps, they're much higher, and they are often, you'll hear an expression, they're institutionally acceptable. They're being a form that a bank will accept. And so as part of this, getting all these documents knitted together, the appointments are typically in a bespoke form.
So at this point, we've seen the way the contracts fit together and the forms of procurement. So I'm just going to come on to collateral warranties. I'll try and make it more interesting than it sounds. So what is a collateral warranty? Well, it creates a mini contract between the warrantor and the beneficiary. So typically a consultant might give a warranty to a funder. The judicial definition, which is on the slide, is taken from the Swansea Stadium Management Company case, is that a collateral warranty provides a direct right of action for the party receiving the warranty against the person giving it. So a collateral warranty creates a mini contract, even though the receiving party wasn't a party to the underlying contract. Now, there's a clue in the words here. It is warranting something that is collateral to the underlying contract. So why do you need to create lots of mini contracts? Well, the initial point is that I'm sure you'll all know, you can't sue on a contract if you're not party to it, and that's known as privity of contract. You have to be a party to a contract to be able to sue someone under it. But why not sue in negligence? As defined, negligence is when a party owes a duty of care to someone and it is in breach of that duty and causes the other party a loss. So why can't an employer, for example, just bring a claim in negligence against a subcontractor? Let's take an example. There's a car accident. One driver drives into another car. The two drivers don't have a contract together, but drivers owe the other road users a duty of care. So if a driver hasn't driven properly and they're in breach of that duty owed to other road users, because of this, they'll need to pay the loss that flows from the breach, or more likely the driver's insurance company will, but the principle is the same. That is essentially the basis of a claim in negligence. So why is construction different? Why can't an employer or a funder sue in negligence against a contractor or a subcontractor? Surely they owe them a duty of care. The answer is no, and the reason why it's no is basically a fudge. So to understand why this is the case, we need to go back in time to Anne's and Merton London Borough Council and also Murphy and Brentwood District Council. So in the 70s, when defects arose in buildings, some people chose to sue the building control officer for getting it wrong. So for example, they failed to spot poorly constructed foundations and other works. So those individuals didn't have a contract with building control, but they could still sue them because the argument was the building control officer owed the owner or the purchaser or the tenant a duty of care. In the late 1970s, the House of Lords decided that building control were liable for their cock-ups to parties with whom they did not have a contract and that they were negligent. But the problem is it made everyone else look to suing building control. So if you sue building control, you're suing the government. And if you're suing the government, you're suing you and me as taxpayers, and you and me are paying those claims. So a similar claim came to the House of Lords in the 90s, Murphy and Brentwood. Murphy and Brentwood actually overturned Anne's and said you cannot pursue a claim in negligence for economic loss against a party with whom you do not have a duty of care. So they went on to say in a construction context, there was no established duty of care, for example, between a subcontractor and an employer, even though the subcontractor knew exactly who the employer was and who was going to get the benefit of the work. Now, in reality, there's no difference between this scenario and a car accident. But the reason this was decided was a public policy reason, in truth, because you can't effectively have the public paying for individual building defects. Not sure how that squares with the current cladding claims, but that's a discussion for another day.
So you can't bring a claim in negligence, and lots of parties do not have any contracts with others that they want to have the right to bring a claim if something goes wrong. So what you have to do is create lots of mini contracts known as collateral warranties. Now here is my diagram from 2007, and despite the criticism of it earlier, it still works. Probably could do with a bit of updating. Now it's the same drawing, but the dotted lines represent collateral warranties. Now what you will see, that the subcontractors are required to give collateral warranties to the funders, the purchasers, the tenants, and the employer. Now, they're predominantly required to give those warranties, for example, because if the contractor goes bust and there are defects in the building, the relevant parties want to be able to sue someone. So all the dotted lines represent collateral warranties. Now, for those of you who like to add up, for your average subcontractor, you'll see there's maybe 4. For your average consultant, there may be 3. If you've got 8 consultants and 10 subcontractors, all of a sudden you've got 64 warranties. So what you end up with is a whole raft of mini contracts because of Murphy and Brentwood. So the reason the collateral warranties are there is essentially because of Murphy and Brentwood saying you cannot bring a claim for economic loss, and construction defects are treated as economic loss unless you have a mini contract. So that's why they're there. Now, a word of warning with collateral warranties, and again, Hannah's hinted to this already, it's a collateral warranting the underlying contract. Well, if you're warranting the underlying contract, you need to know what the underlying contract says. For those of you who've ever looked at collateral warranties or get involved with it, you'll recognize you have clauses that say the warranting party can rely on any defense in the underlying contract, can raise the same set-offs, those sort of clauses exist. So if you are obtaining collateral warranties, you need to ensure that you've seen the underlying contract, the underlying appointment, to make sure there's nothing in there that's going to impact on the value of the warranty. There is also, and I think it was the Swansea case as well, where the court said, even if you don't have those clauses saying you can rely on these same defenses, there is the principle of equivalence, which means you cannot be any more liable under a collateral warranty than you could be under the underlying document. So the key is And again, it all comes back to this sort of fitting in, understanding this whole contractual structure. Any collateral warrant from any party, including subcontractors, you need to be able to see the subcontract to make sure that your warranty isn't affected by the underlying contract.
So having considered the general principles and law behind collateral warranties, we're going to consider the various forms of collateral warranty. So there are industry forms of warranty in circulation. JCT produce them, CIC produce them, British Property Federation used to. I think the National Housing Federation may do one. However, there's a problem with them. They have limitations, and it comes back to that overall contractual structure. So more often than not, you will find that funders, purchasers, tenants insist on non-standard forms just to protect their position. So there are also issues in that the standard forms do not provide a full suite. For example, JCT do not produce a consultant warranty, CIC do not produce a contractor warranty, making it difficult to achieve consistency across all of the warranties, which a beneficiary will usually expect. Now, I've put the Bank of England on this slide, but it's not really the Bank of England. It's essentially the person giving the money for the job. So whilst you may think the employer's lawyer is being unreasonable, it's probably the bank with those requirements. If those requirements aren't met, they won't lend the money. So that's why you have bespoke forms of warranty. Moving on to our next topic, novations.
You again.
It is me again. So what's the judge's view on novations? Well, this is on the slide. Now, it's the process by which a contract between A and B is transformed into a contract between A and C. Now, that's quite helpful. Now, there are essentially three types of novation, but by far the most common is what's called an ab initio novation, which I'll come on to shortly. But what actually is a novation? It's the transfer of interest from one party to another. So unlike assignment, novation transfers both the benefit of a contract and the burden of a contract. So it's the contract between party A and party B that's transferred to party A and party C. At the point in which novation happens, party B is no longer liable for any fees. So it extinguishes the previous contract and replaces it for a new one on the basis that it always was, which is what is meant by ab initio, as I'll come on to next. I can't say I'm at one with my Latin, but what ab initio means is from the beginning. So when it's transferred as if it always was from the start. So any pre-novation breach by the novated party, which is typically a consultant, is caught by this. So the contractor can sue for any breach that occurred before the novation. Less common is a switch novation. Now, this means the contract is deemed to switch from the date of the novation rather than as it always had been, which means anything pre the switch still sits with the employer and anything post the switch sits with the new party, typically the contractor. They're quite rare switch novations. You can also have novation by conduct. I wouldn't recommend it, but if the parties effectively act on the basis of novation, then arguably there has been a novation by conduct. As you can imagine, this is probably going to give rise to arguments later on down the line, so you're better off having a formal written novation agreement in place.
I'm back. So when do novations occur? Well, hopefully you've picked up on this. The most common is novating a professional appointment from the employer to the contractor in a design and build situation. The reason you're doing that is the contractor is going to say to you, I am not going to take the design risk for pre-contract design unless I can sue the person who might have got it wrong. And instead of having a collateral warranty from that person, they tend to get novated. That means that that designer then can finish the design for the contractor. I think that's my discernable. You start at the position, as we've seen before, where the employer is employing the design professionals. Novation transfers all the rights to the contractor for anything that's done pre and post. So the design professional, one of the issues that comes with this is, are any money is left to be paid by the employer at the time they're novated to the contractor? So that you can't sort of ignore these issues that arise. If you go on to the next slide, you'll see that essentially what happens is it moves up and what you have is it gets transferred to the building contractor. The employer is then saying, well, hold on a minute, what if the building contractor goes bust in 5 years' time and I've got problems with my design? I've thrown away my appointment with my designer. So what you get back is a collateral warranty from your design professional to your employer. Again, it's a very obvious thing. So that's the classic situation where a novation occurs. There is a City of London Law Society, should you be interested, form of novation that is the simplest and the best to use, and that just simply transfers all the rights from one to the other and transfers all the obligations from one to the other. As I said, you have to be slightly careful about fees. You have to also be slightly careful about services, because you end up in this situation where the original appointment between the designer and the employer says the engineer might say, we'll check the contractor's work or something. Well, the contractor isn't going to want the engineer to be reporting back to the employer once they've appointed them. So there will be a bit of movement on services and potentially on fees. And yeah, as I've already said, don't forget that the collateral warranty goes back to the employer. Back to you.
There's another scenario where novation commonly takes place, and that's with enabling works contract. So this is where an employer will get the enabling works sorted early on, and the main contractor is employed for the full works. This enables the employer to get all the pipe work and the connections, etc., and drainage out the way. So the employer will typically employ the enabling works contractor under some form of contract, often a trade contract. However, the employer, or more likely the funder, only wants one party with design responsibility and wants that to be the main contractor. So they say to the main contractor, when you're appointed, you'll take a novation of the enabling works contract. So if the enabling works have any issues with them, it's the main contractor's problem. Now, in this case, the main contractor would have to claim against the enabling works contractor for any issues in the enabling works. So these next slides just explain the point I was making with the enabling works contractor being novated over to the building contractor. There's a few practical issues with novations, as Andrew sort of touched on, and particularly in focusing on enabling works on this slide. So when does the novation take place? Because you're the novated party, you might prefer to be paid by the employer rather than the contractor. So you need to work out when that novation actually happens. Also, what form of contract is being novated? What are the services? There may need to be some sort of agreement between the parties to amend the terms of that original enabling works contract.
Here we go.
There you go. So the final part of this session, if you're still with us, which hopefully you are, is design. And the first topic I want to talk about is the scope of duty of care for design. So starting off, it is really important to be clear about the standards that apply for each part of construction works, because they are different. So the test for workmanship is whether the work has been carried out in a good and workmanlike manner. The test for the quality of materials is whether they are fit for purpose. And the test for design is whether the design has been carried out using the reasonable skill and care of a designer. Now, it is vital that the skill and care referred to for design is the reasonable skill and care of a designer. Now, we need to go back to 1980 to explain why this is the case, and the case of IBA and EMI and BICC. But just before I come on to that case, I just want you to have a look at the JCT 2024 suite. So clause 2.17, which is on the slide, deals with the standard of care that is applicable to design. Now, I'll talk about why this is important in a moment, but this is a contract between employer and contractor. So it refers to the contractor designing the works using the standard of skill and care of an architect. Now, this may look unusual because your contractor is a contractor, not an architect, but I'll come on to the reason why this is the case now. So the IBA and EMI case related to the construction of a TV mast on Emley Moor. As a result of high winds and ice and something called vortex shredding, this occurred, which resulted in the mast collapsing. So at the time, the contractor, who is the EMI, had appointed BICC to carry out the design. However, there was no express reference to the nature of the duty of care for EMI towards the employer, who is IBA. Now, in this case, the court distinguished between a contractor's level of skill and care as opposed to that of a designer. So the court effectively said that in the absence of any contrary wording, a contractor guarantees that the finished product is fit for purpose, and this includes the obligation for design, whereas a designer, BICC, only warrants to use reasonable skill and care of a designer. So what is in practice and what has emerged is this bizarre situation where a contractor's duty of care for design is higher than that of a designer. So this is why it's important that any reference to the standard of care for design is to be that of a designer and not a contractor. It's explained by the court saying that the contractor is delivering a product that it promises will work. The designer is only promising to use reasonable skill and care. So in both NEC and JCT, the standard forms refer to the reasonable skill and care to be expected of a designer, even though these are contracts for contractors, effectively removing the issue created by this IBA and EMI case. So as well as the IBA case, there was a relatively recent case of MT Hogard. Now, this claim related to the Robin Rigg wind farm, a large wind farm in the Solway Firth. Now, unfortunately, the grouting to the foundations failed. It was accepted that the design carried out at the time was to recognise standards. It's just that the standards weren't correct. So the cost of repair was some 23.6 million. In simple terms, there were conflicting clauses in the contract between the parties. One clause said that the contractor was to use the reasonable skill and care of a designer, which it did. However, there was a provision tucked away in a specification saying that the foundations would have a design life of 20 years. Now, it was this latter point that was seen as a fitness for purpose obligation. The exact words were, the design of the foundations shall ensure a lifetime of 20 years in every aspect without planned replacement. So the court therefore had to decide what happens where there's these two conflicting terms. And they came to the conclusion that the higher standard applies, and Hogard was ordered to pay £23.6 million. So if you have competing clauses in your contract, beware the fitness for purpose clause will apply. And as with the Hogard case, sometimes these are hidden away in specifications and they're not in your front end of your contract. So it's really, really important these specifications and similar documents are checked.
So you ask, well, why does it matter about this reasonable skill and care point? Well, the answer is your PI insurance is what matters. So if you look at the clause on the right-hand side, if you sign up to a fitness for purpose clause, your PI insurance will not cover it. Now, if you look at it, it says, we will not indemnify you for any liability arising from any fitness for purpose guarantee. And it also says your agreement to exercise a standard of care greater than would be normally expected in your profession. Now, they say basically a designer. So your PI insurer is saying you must not sign up to anything that says, I will use, I will guarantee fit for purpose, or I will use reasonable skill and care. So, and PI insurers are even worse than that, because they'll say, even if the problem was just one of not using reasonable skill and care, because you've signed a contract that says fits for purpose, we're not covering you at all. So that's why it's really important to understand this point on design. So to make sure you don't fall foul of this, fall foul of being outside, you need to check that any reference in your contracts to design and build is that of a designer, not a contractor. And if you're using the standard forms, that's not necessarily a problem. But you will get additional clauses that will say you'll guarantee the works are fit for purpose. Well, part of the works includes the design. So it comes back to what Hannah said before. You've got to be very careful about separating out workmanship, materials, and design, and make sure they are defined by the proper standards. You will also get clauses that say you will comply with any performance specification. Coming back to Hogard, the performance specification said there'll be no maintenance for 20 years. Well, the court decided that was a fitness for purpose clause. So all these sort of tricks are trying to, almost whether they're trying to catch you out, but could run the risk of you accepting a contract with a fitness for purpose clause. So you need to make sure that that's not the case. And the other thing I will say is we find it quite common that collateral warranties are drafted differently. So they are referring to the reasonable skill and care of a contractor, even though the underlying contract might be referring to that of a designer. So that's a red flag as well. I should also say, I forgot this, that FIDIC, if you are ever using FIDIC, FIDIC has a fitness for purpose clause in it because it's an international contract. It's not designed for UK works per se. So if you are using FIDIC, that clause has to change. what we're finding now is it's not uncommon. In fact, it's actually common for contractors who understand this to have a clause in it saying, so not only are they changing the references to contractor to designer, but they're putting an overarching clause that says, notwithstanding any other term of this contract, the contractor's liability for design shall not extend to one for fitness for purpose. So it sort of gets rid of that risk of it something being in the performance spec. And you will find on the next slide that JCT has introduced, I know these things get changed, as I said earlier, but JCT at clause 217.2 has introduced this type of catch-all clause. So it's said in there, the contractor should have no greater duty to exercise reasonable skill and care, and any such design shall be fit for its purpose. So they're basically saying we're not going to impose a fitness for purpose obligation on you as well. And that the purpose of that is to reflect HOGARD and reflect the fact that PI policies won't respond to a contract where there's been a fitness for purpose obligation. Oh God, it's me again.
It's you again.
I thought we'd moved everything onto you. As part of the overall design shift that we've talked about, and novation and design and build, you also get what's discrepancy risk. Now, you'll know in JCT, certain contracts and the bigger ones can have volumes of documents. There are always going to be some discrepancies between those documents. So who takes the risk for that? Because that is an element of design. So if you look on the slide, the JCT unamended position is effectively that the employer takes the vast bulk of the risk. So if there's any error in any design, any documents, so the discrepancy between the documents, the employer takes that risk. If there's any discrepancy between the site boundary and the employer's requirements, the employer takes that risk. The only one the contractor takes risk for is where the contractor's documents themselves contain discrepancies. Now, for those of you who've been listening, it won't come as any massive surprise that when these clauses are amended and a full design risk is shifted to the contractor, these clauses change. And what you find, each of these separate clauses changes. Now, clause 2.9, which is about who takes the risk for the building fitting on the site, I have to say, when these ones come up, I don't think that is a risk a contractor should take, even in a lawyer drafted contract. I think there are certain risks an employer has to retain. And I think, the site boundary is an employer risk. Beyond that, though, 211, 212, 213, 214, they're all clauses that say, well, what if there's an inadequacy or an omission, an error, an inconsistency? All those clauses are changed if you're going to have full design and build risk. And we've had a number of questions which we'll deal with. I'll explain how we're going to deal with questions. But they are all going on about, what about pre-contract design? And the amendments you get to JCT by lawyers on behalf of their funders are shifting all those sort of possible arguments that that's an employer risk, shifting them all to the contractor side. So in answer to some of those questions, it's the amendments that shift the pre-contract risk to the contractor.
So when we say full design responsibility, we mean full design responsibility. But to achieve this, we need to have various amendments to the terms of the JCT, as Andrew's just touched on. So the standard form and the design and build form have these recitals. Now, these place an obligation on the employer to check the contractor's proposals. Now, to transfer full design responsibility to the contractor, these clauses are reversed, and you'll commonly see these in amendments where the contractor is taking full design responsibility. So they'll say that the contractor has checked the employer's requirements and is happy with the contents. Similarly, clause 2.1, 211, 214, 217, these are all reversed, so the contractor takes full design risk. And there has been a question mark as to whether these amendments are enough to transfer full design responsibility from employer to contractor. And there's been a recent case on this which says, yes, those amendments are enough. So the case is on the slide. It's Workman Properties and ADI Building. So the dispute related to who had responsibility for the design. ADI said when they took on the job, they were told it would be a REBA stage 4 design. So they were only responsible for design post stage 4. The design was not that far progressed, so ADI said they were entitled to more money and an EOT because the design wasn't as progressed as it should have been. It was effectively agreed that the design was not as far progressed as it should have been, and which won't come as a surprise to many of you on this webinar. But the contract was amended. Guess what clauses were amended? The third recital was reversed, clause 2.1 was amended, clause 2.13.14 was amended, clause 2.17 was amended, and all of these clauses transferred full design risk to the contractor. So the question was whether all the contractual amendments superseded this statement in the ERs that the design would be up to stage 4. Now, the court said that the reference in the ERs did not even come close to changing the agreed contractual position. ADI took the full design risk, so the risks stayed with them and it wasn't an employer risk. So full design responsibility can be passed on to the contractor, as this case shows, but it needs to be done correctly with the right clauses being amended.
So any questions? We're slightly ahead of what we expected to be. So I'm going to answer. We've had a few questions and a couple of interesting. One recent one, what form of contract would we recommend? Which version? Well, you can use, what we're finding is 2024 is clearly becoming more common for JCT at least. We are finding some organizations still use 2016. There's nothing wrong with still using 2016, but you have to bear in mind, for example, 2016 has no Building Safety Act clauses, does not have that fitness for purpose clause. Those sort of clauses are not in there, but there is no fundamental reason why you can't use 2016 compared to 2024. It's just I think the best way to look at it is there's no fundamental reason why you shouldn't be using 2024. I think it is often as simple as the fact that some organizations have a set of amendments to 2016 and haven't yet got around to changing it. So either is fine, but we would recommend 2024. There was one other question that sort of piqued my attention, which was one of the issues with novation, where you have professionals are novated to the contractor and then they're expected to effectively tell tales to the employer. And you have a situation where sometimes the employer says, well, I want to retain the contract and the professional to do some things for me, or I want the professional to report back to me. Now that's very complicated. It's not complicated legally, it's complicated practically, because the person paying the consultant is the contractor. The contractor does not want that consultant telling tales to the employer to say, the contractor's got this wrong, that's what the reason for the delay is, etc., etc. So this idea of a Chinese wall in two parts of an organization is tricky. It's done quite regularly, but it is tricky. And, if possible, I would recommend that you have if you want that sort of, you need the reliance on your professional team. Don't novate them. Agree with the contractor, a sort of hybrid version of that.
I'm going to do an easy question. Are the slides going to be available? Yes, they are. We'll make sure they're available after the webinar. We've had a question about, do you know what percentage of D&B novate the design as opposed to bringing in their own design team? I don't know that.
Well, I think the answer is it's still the case that developers in particular will default to a pure design and build. And what comes with a pure design and build, let's say 90% of the time, is a novation. What we are seeing is novated consultants who are novated to a contractor are often having very reduced services. So the contractor is almost taking the novation and then employing their own designer as well. So they've effectively backed off their legal risk, but then employing someone who suits them. So there is a change in the market a bit, and it is definitely the case that there are certain consultants who are better on one side of the fence. Now, there are certain consultants who are good at both, but so as a percentage, difficult to say, but the vast bulk of jobs remain, certainly when you've got funded schemes, pure D&B with innovation.
Okay. Under the design and build, the employer is not given the right to approve designs. I think that some contracts, employer does try and retain the right to approve things, even though it's a full design and build. And you'll see clauses, particularly in employers' requirements, to say this sort of thing we need to give you approval on first. It depends on what job is and who the employer is.
Yeah, and I think the issue, I don't know, the issue with that question is probably the contract says the contract will have a set of employers' requirements. So if the contractor has to comply with those employers' requirements. If there's something vague in those employers' requirements, then the contractor is at liberty to decide what he wants to do, provided they meet those employers' requirements. So I wouldn't necessarily use the word approve, because employers don't tend to approve designs, because they're always turning around saying, we haven't approved it, or if we have approved it, it's not our risk. So it's a question of what's in the ERs. You will also see in some contracts clauses such as design development, which is saying even if this isn't part of the ERs, anything that flows on from the ERs is your risk as well. So it's a question of what's in the terms.
This is quite an interesting one, where clauses 2.1, 2.11 to 2.14, 2.17 are amended in the main contract to push the design risk onto the contractor. If they aren't amended in the subcontract, is the subcontractor still at risk, as they're aware of the main contract and have to sign up to the same amendments?
Well, that gets tricky. In the JCT subcontract, standard clause 2.5 is a main contractor indemnity. The subcontractor is required not to put the main contractor in breach of the main contract. I think the problem for the main contractor in this scenario is if the subcontractor isn't responsible for discrepancies, they're not necessarily putting them in breach. They're just saying there's a discrepancy, you have to pay me. That's not putting the main contractor in breach of his contract. It's just saying you have to pay me. I'll correct the discrepancy. You just have to pay me for it. Whereas the main contractor has to correct the discrepancy and doesn't get paid for it. So I think the truth is the subcontractor would still be entitled to money and the main contractor would not in that example.
And the easier thing is to amend your subcontract, so the amendments in your main contract flow down to your subcontract. Yeah,
and it is typical, if again for bigger schemes, that there are sets of amendments for subcontracts, and those subcontracts, if we're doing them for our clients, we will have a set of amendments to a subcontract that reflect the type of thing you're going to get on a main contract. And trust me, every design and build contract that is drafted by a lawyer, or not even a lawyer, project managers who know what they're doing, QSs who know what they're doing, will change clause 2.1, 211, 212, 213, 214. So you might as well put it in your subcontract because they're going to be changed anyway. I think if we call an end to that, what I was going to do, the plan on questions was, we've had a lot of questions, and I think for two reasons. There's one, I think my plan is to send out a question and answer sheet so everyone can see. Well, we won't necessarily name names, although actually these are all on the public one, so maybe you can see anyway. And we'll give you the answers that are appropriate. But also for the next session, which is about the Construction Act, payment notices, pay less notices, and that interesting stuff. For those of you that have seen my sort of talks before, I have some trick questions about bank holidays. And so I'm going to send those questions out a week before. So what we'll do is we just send you an email or whatever that's got the answers to the questions that have come up. And also this sort of, I wouldn't go over the top. I wouldn't spend hours on it. But if for the next session, if you're going to be in the next session, there's going to be 3 or 4 questions in there. And it would help if you've read them before. There's lots of sort of questions come up about, are these recorded? Where are they recorded? Yes, they are recorded. Heaven forbid you'd want to watch it again, but they are. I think they're put on YouTube, but we'll confirm where you can see that. They're all recorded. And, hopefully this first session hasn't put you off the next 5. We'll find out how many people come to the next 5. And with no further ado, we'll end that webinar with 10 seconds to go.
Lovely. Thanks, everybody.